Criminal Code of Cambodia, 2009, Rules applicable in case of concurrent offences. Title 4, Rules applicable in case of concurrent offences, Chapter 1, General Rules, Article 136, Concurrent Offences. Concurrent offences take place when an offence was committed by a person before she has been definitively sentenced for another offence. Article 137, Unique Prosecution. During the course of a unique prosecution, when the accused is found guilty of several concurrent offences, each penalty may be pronounced. However, when several penalties of the same nature are imposed, the court shall pronounce only one offence of this nature, to a certain extent of the legally allowed highest maximum. Each penalty is considered as joint penalty with the concurrent offences, to a certain extent of the legally allowed highest maximum applicable to each among the penalties themselves. Article 138, Separate Prosecution. During the course of a separate prosecution, when the accused is found guilty of several concurrent offences, the offences pronounced are carried out concurrently to a certain extent of the legally allowed highest maximum. However, the total or partial merger of the penalties of the same nature may be ordered by the last court which adjudicates the case. For the enforcement of this article, in the event of the convicted person is imposed to a life imprisonment, the legally allowed highest maximum is fixed at 30 years of imprisonment, if the accused has never been sentenced to life imprisonment. The suspension of penalties in whole or in part of the pronounced penalties for the concurrent offences does not hinder the execution of the penalties of the same nature whose suspension is not granted. Chapter 2, Separate Rule. Article 139, Cause of amnesty and reduction of penalties on the merger. When a penalty is subjected to a measure of amnesty and reduction of penalties as prescribed in Article 27 of the Constitution, for the enforcement of the rules on merger, the penalty resulting from the amnesty and reduction should be taken into account. The duration of the reduction of the penalties includes the duration of the penalty to come, if any, after the merger. Article 140, Merger of Fines. In variance to the preceding provisions, the fines pronounced for several petty crimes accumulate themselves and with the fines pronounced for the felonies or misdemeanours. Article 141, Non-merger of penalties pronounced for prison escape. In case of conviction for escape, the penalties pronounced for escape accumulate themselves, without having the possibility for merger, with those pronounced for the offence whose reason has caused the escaped prisoner to be detained.